एक चेक बाउंस की कंप्लेंट में अगर कंपनी के अगेंस्ट चेक बाउंस का केस फाइल किया गया है तो एक नॉर्मल प्रैक्टिस है कि जितने डायरेक्टर्स हैं उनको बाय डिफ़ॉल्ट जो कंप्लेनेंट है एक्यूज्ड पर्सन बना देता है। तो अगर आप भी डायरेक्टर हो और खासकर नॉन सिग्नेटरी हो, आपने चेक के ऊपर साइन नहीं किया या आप नॉन एग्जीक्यूटिव डायरेक्टर हो, तो उस केस में क्या चेक बाउंस का ट्रायल आपको भी पूरा का पूरा देखना पड़ेगा? क्या चेक बाउंस के केस में आपके ऊपर भी लाइबिलिटी आने वाली है अगर ट्रायल जो है कन्विक्शन की तरफ जाता है? इन सारे क्वेश्चंस का आंसर हम आज एक वेरी स्पेसिफिक सिनेरियो के साथ, इफ़ यू आर ए नॉन एग्जीक्यूटिव डायरेक्टर, तो आज हम जो ऑनरेबल सुप्रीम कोर्ट की जो जजमेंट है के.एस. मेहता वर्सेस एम.एस. ऑर्गन सिक्योरिटीज एंड क्रेडिट्स प्राइवेट लिमिटेड, इस जजमेंट को गो थ्रू करेंगे। ये जजमेंट ऑनरेबल सुप्रीम कोर्ट की मार्च 4 2025 में आई। इट वाज डिलीवर्ड बाय टू जज बेंच ऑफ द ऑनरेबल सुप्रीम कोर्ट एंड जो जजेस थे वो थे ऑनरेबल जस्टिस बी.वी. नंगरत्ना एंड ऑनरेबल जस्टिस सतीश चंद्र शर्मा। अब इस रिक्वायरमेंट को डिटेल में समझने के लिए वी विल गो थ्रू दी वेरियस फैक्ट्स ऑफ द केस। हम थोड़ा सा टाइमलाइन के बारे में समझेंगे इस जजमेंट की, फैक्चुअल कैसे ट्रैवल किया फ्रॉम द ट्रायल कोर्ट से ऑनरेबल सुप्रीम कोर्ट तक, फिर ऑनरेबल सुप्रीम कोर्ट का एनालिसिस समझने की कोशिश करेंगे, वाइकेरियस लाइबिलिटी ऑफ ए डायरेक्टर इन ए चेक बाउंस केस एंड वेरियस जो जुडिशियल प्रेसिडेंट्स थे जो ऑनरेबल सुप्रीम कोर्ट ने रीअफर्म करे, उनको रेफरेंस की तरह देखा भी, एंड विल गो थ्रू द फाइनल वर्डिक्ट एंड वी विल ट्राई टू अंडरस्टैंड दैट इस जजमेंट के कारण कंप्लेनेंट को क्या स्टेप्स लेने पड़ेंगे, या फिर अगर आप एक्यूज पर्सन हो और नॉन एग्जीक्यूटिव डायरेक्टर हो तो आपको किन स्टेप्स का ध्यान में रखना है सो दैट आप अपने आप को प्रॉपरली रिप्रेजेंट कर सको एक चेक बाउंस केस के ट्रायल के अंदर। एंड बिफोर गोइंग इनटू डिटेल ऑफ दिस जजमेंट, हमने ऑलरेडी अपनी डिस्क्रिप्शन में प्ले लिस्ट का लिंक दे रखा है। ये जो प्ले लिस्ट है वेरियस रिसेंट जजमेंट्स जो कि ऑनरेबल सुप्रीम कोर्ट एंड ऑनरेबल हाई कोर्ट्स के द्वारा दे रखी हैं इन द डोमेन ऑफ चेक बाउंस मैटर्स, वो हमने वीडियोस क्रिएट कर रखी हैं। You can go through these videos and in case you have any specific questions, specific queries, आप हमें ईमेल कर सकते हो या फिर कमेंट बॉक्स के अंदर भी हमें कमेंट डाल के पूछ सकते हो। We will try to answer your questions on ASAP बेसिस तो नहीं बोलूँगा, लेकिन एज जैसे जैसे टाइम की अवेलेबिलिटी होगी हम आपके क्वेश्चंस का, क्वेरीज का आंसर इन ए मिनिमम टाइम शेड्यूल में आंसर करने की कोशिश करेंगे। एंड नाउ लेट अस गो डीपर इनटू दिस जजमेंट। सबसे पहले हम फैक्ट्स को समझने की कोशिश करते हैं। तो अगर हम कंप्लेनेंट के पर्सपेक्टिव में बात करें, जो कंप्लेंट में अवर्मेंट्स थी वो ये थी कि जो डिस्प्यूट ओरिजिनेट हुआ वो था एक इंटर कॉर्पोरेट डिपॉजिट एग्रीमेंट हुआ था डेटेड सितंबर 2002 के अंदर। और जो कंप्लेनेंट मॉर्गन सिक्योरिटी एंड क्रेडिट्स प्राइवेट लिमिटेड थी उसने लगभग 5 करोड़ की जो फाइनेंशियल फैसिलिटी थी ब्लू कोस्ट होटल्स लिमिटेड को प्रोवाइड करी थी। कंपनी ने जो ब्लू कोस्ट होटल्स एंड रिजॉर्ट्स लिमिटेड है उस कंपनी ने पोस्ट डेटेड चेक्स जो थे इशू करे, एंड जैसे कि चेक बाउंस मैटर में पता है कि जैसे वो जो चेक इशू हुए, प्रेजेंट हुए, डिसऑनर्ड हुए, एंड डिसऑनर्ड के बाद डिमांड नोटिस भेजा गया, एंड डिमांड नोटिस के बाद जो है कंप्लेंट फाइल कर दी गई। ओके, अगर हम एक्यूज के एंगल से अब बात करें, क्योंकि यहाँ पे दो ऐसे एक्यूज थे, को एक्यूज थे जो कि नॉन एग्जीक्यूटिव डायरेक्टर्स थे। जैसे ही इनके अगेंस्ट कंप्लेंट फाइल होती है तो ये क्वैशिंग प्रोसीडिंग्स के लिए पहुंच गए थे ऑनरेबल दिल्ली हाई कोर्ट के पास, वी विल गेट टू नो। लेकिन ओवरऑल अगर हम स्टैंड देखें एपिलेंट का स्टैंड क्या था, दे आर सेइंग दैट दे हैव ए लिमिटेड रोल ऑफ ए नॉन एग्जीक्यूटिव डायरेक्टर। जो एपिलेंट इसमें दो थे, के.एस. मेहता थे एंड मिस्टर बसंत कुमार गोस्वामी, दैट दे सेड दैट दे आर रॉन्गली इम्प्लीकेटेड। लेकिन मेजर डिफेंसेस उनके ये थे, दे वर अपॉइंटेड एज ए डायरेक्टर्स एट डिफरेंट टाइम्स but their designation was that of a non-executive director. This is very very important. Okay, they held that this role to comply with the SEBI's listing agreement requirement. So basically जो एक्यूज पर्सन जो थे, वन ऑफ द एक्यूज पर्सन दे वर द नॉन एग्जीक्यूटिव डायरेक्टर्स, और जो यही एक्यूज पर्सन ऑनरेबल सुप्रीम कोर्ट के पास पहुंचे एंड दे सेड दैट हम तो नॉन एग्जीक्यूटिव डायरेक्टर्स हैं, जो सेबी के लिस्टिंग एग्रीमेंट की जो मैंडेट है उसके अंडर ही हमारा अपॉइंटमेंट होता रहा है और वेरियस टाइम पीरियड के दौरान हुआ है, and during such time period they did not have any executive authority or power in the company's financial decision making. And very importantly, they said that they were never in the attendance at the board meeting on September 9, 2002 where the ICD transaction was approved. So complainant का स्टैंड ये था कि एक आईसीडी एग्रीमेंट हुआ था 2002 में, उसके बेसिस के ऊपर कंप्लेनेंट ने फाइनेंशियल फैसिलिटी रिलीज करी थी, लेकिन यहाँ पे ये दो नॉन एग्जीक्यूटिव डायरेक्टर्स जो कि ऑनरेबल सुप्रीम कोर्ट के पास पहुंचे, दे सेड कि 2002 के अंदर जो एग्रीमेंट भी हुआ था, इवन वहाँ की बोर्ड ऑफ डायरेक्टर्स की मीटिंग में भी दे वर नॉट प्रेजेंट, दे वर नॉट द सिग्नेटरी ऑल्सो to the checks, and they were also not signatory to the ICD agreement or any other financial instruments including the dishonored checks. So that's the the area of defense of these accused persons. तो अभी तक तो हमने फैक्चुअल नरेशंस समझे। अगर हम लॉ के पर्सपेक्टिव में बात करें तो सेक्शन 141 जो है दैट गेट्स इन्वोक्ड जैसे ही आपने किसी डायरेक्टर को एज ए को एक्यूज बनाया है इन ए चेक बाउंस कंप्लेंट। सो factual dispute set the stage for a significant legal question before the honorable supreme court, और वो ये क्वेश्चन ये था, the core of the conflict was कि कैसे correctly apply किया जाए section 141 of the NI Act to determine the director liability, especially for the directors who were not involved into the day-to-day affairs of the company. So क्या आप डायरेक्टर हो तो ऑटोमेटिकली इट इज प्रिज्यूम्ड दैट you will be involved into the day-to-day affairs of the company or not. So these are the couple of questions which we are going to get answer from this judgment of the honorable supreme court. अगर हम केस की जर्नी के बारे में डिस्कस करें तो ये ऑनरेबल मजिस्ट्रेट कोर्ट से जैसे ही समन्स के ऑर्डर इशू होते हैं तो जो एक्यूज पर्सन हैं वो दिल्ली हाई कोर्ट को अप्रोच करते हैं फॉर क्वेश्चनिंग दी समनिंग ऑर्डर्स, क्वेश्चन पटिशन डालते हैं एंड देन उसके बाद ऑनरेबल सुप्रीम कोर्ट के पास मैटर पहुंचता है जब दिल्ली हाई कोर्ट डिसमिस कर देती है क्वेश्चन पटिशन को। And let's see now what is the analysis from the honorable supreme court. तो ऑनरेबल सुप्रीम कोर्ट के सामने कंप्लेनेंट्स के जो आर्गुमेंट्स थे दे वर प्राइमरीली फोकस्ड ऑन दीज पॉइंटर्स. फर्स्ट वाज दैट द कंप्लेनेंट आर्ग्यूड फॉर ए वाइडर इंटरप्रिटेशन ऑफ डायरेक्टर्स लायबिलिटी. ऑब्वियसली आई एम बीइंग ए कंप्लेनेंट तो मैं यही आर्ग्यू करूंगा कि ओके दे वर द डायरेक्टर्स, दे वर अवेयर ऑफ द डे टू डे अफेयर्स ऑफ द कंपनी. So quashing petition should not be allowed qua the accused persons who have approached the honorable Supreme Court. The second jo limb of argument by the complainant was that the appellant names appeared as directors in the company records at the relevant time, creating a presumption of the involvement. So that's something this limb of argument which was opened up by the complainant, that since I was the director, right? So then it will be there it will be presumed that I'm aware of the day-to-day affairs of the company. Whereas section 138 जो NI एक्ट है, जो section 139 है हमारा, उसमें प्रिजम्पशन कहाँ पे आती है? इट इज द प्रिजम्पशन इज ओनली अबाउट द existence of a legally enforceable debt between the complainant and the accused, right? लेकिन वाइकेरियस लाइबिलिटी के, डायरेक्टर्स की वाइकेरियस लाइबिलिटी के ऊपर कोई प्रिजम्पशन एज्यूम नहीं की जा सकती. Then third limb of the argument from the complainant was that resignation does not automatically absolve liability for offenses during their tenure. And this was one of the common argument taken by the complainant, which is the burden of proof lies on the accused directors to establish their non involvement, which must be decided during a full trial. And that's a typical, a stand taken by the complainants when accused approach the higher forum, maybe high court or maybe supreme court. Then the complainant stand is generally that, let the accused face the trial, let the accused establish their innocence before the trial court by leading the evidence. And that's what exactly in this matter also the complainant took the similar stand, that the questions that whether they were involved or not, that's a matter of a trial, right? And let the full they face the full trial. And finally, the attendance at the board meeting suggested knowledge of the company's financial dealings, including the ICD and issues of the check. So the complainant cited that, they were involved into various other board meetings. So that automatically means that there, yes, there existed an ICD agreement, yes, there existed certain checks which were issued to the complainant. So broadly the complainant tried to made a picture that yes, the non-executive directors were fully aware of the day-to-day operations, and they were fully responsible, equally liable for the dishonor of these checks. Whereas from the accused person's perspective, their first argument was that, since they were not the signatories to the dishonor checks and had not authorized their issuance, they could not be held directly liable. So जो चेक डिसऑनर्ड हुए उनके ऊपर इन accused person के साइन नहीं थे. Their second argument was that non-executive status limited to the corporate governance oversight as per the SEBI regulations negated any basis for establishing the vicarious liability of a non-executive director. Then their third defense was the criminal complaint was legally untenable because it lacked specific averments explaining how or in what manner they were in charge of and responsible for the conduct of the business. So they specifically highlighted that, look, firstly, there is nothing in the complaint to establish that so and so person was responsible in such a manner which led to the dishonor of the checks. Secondly, they were the non-executive directors. Their role was limited to the corporate governance oversight. So in view of this role, they cannot be considered as liable for the dishonor of the checks. And that's where the honorable supreme court analysis come into the picture, and where the honorable supreme court I would say reaffirm various judicial precedents, because this is going regular way that the people try to rope in those directors also who have nothing to do in the check dishonor process. And that's why the analysis of the honorable supreme court starts with the first major pointer, that the absolute necessity of some specific averments against the director in a NI complaint. So this is a lesson for the complainant also, that if they wish to add any director who is not a signatory, whose role is not confirmed, they must give specific averments, how the particular director, how that person is involved in the financial activities, in the day-to-day affairs of the company, which led to the dishonor of the checks against which the complainant has filed a complaint. The honorable court observed that section 141 is a penal provision creating vicarious liability and must be strictly construed. It cannot be mechanical manner that simply you say it one line and automatically the liability should be attached to that person who is not even a signatory to the checks. So, Honorable Supreme Court referred to its own judgment delivered in another matter in earlier courts, National Small Industry Corporation versus Harmeet Singh Pental, specifically that complaint should spell out as to how and in what manner the respondent was in charge or was responsible of the accused company for the conduct of its business, right? So these averments must be there in the complaint. The second factor which came out very strongly in the analysis was the liability of a non-signatory director in a check bounce matter. Honorable Supreme Court held that they had not signed the dishonored checks, right? And the primary liability for a check dishonored under Section 138 of the NI Act falls on the signatory of the check. Okay, the person who has signed it, definitely he has to face a trial to establish that he was not responsible for the day-to-day affairs of the company. And that's why Honorable Supreme Court held that when the director is a non-signatory, is this fact is a highly significant fact while deciding that whether the non-signatory non-executive director should be made a co-accused, should have, whether that person has to face the trial, right? Even though there cannot be any liability against such person. The third factor, which is very, very critical, is that the role of the non-executive directors. The Honorable Supreme Court placed significant weight on the appellant status as the non-executive directors, because their role was very much limited only to the corporate governance. They were not involved into the financial decision making. They were not involved into day-to-day affairs of the company. They were not involved into the financial management of the company, and that's why attracting liability under Section 141 against such person would be a useless activity. Then other factors were also there, that evidence including ROC records, corporate governance reports demonstrated that appellant's non-executive task only and lack of executive decision making authority. So after going through the arguments of the complainant as well as the arguments of the accused persons who are the non-executive directors, so these are the pretty much findings of the Honorable Supreme Court in favor of the accused person. And then various judicial precedents were cited in this judgment. For example, S.M.S. Pharmaceutical Limited versus Negotiable, where it was held that holding the designation of a director, merely holding of a director, is not enough to fasten the liability. The specific role and responsibility must be established in the complaint, and if it is not there, you are bound to succeed the case in the check bounce matter. This national small industry we have already picked up, and then Pooja Ravinder Devi Dasni was also highlighted, which established that the that non-executive directors are not involved in day-to-day operations, and only those responsible for the daily conduct of the business can be held accountable under Section 141. And then Honorable Supreme Court also relied upon Ashok Shevakar Mani judgment also, where it noted that it was dealing with the appellants who were directors but who had not signed the dishonored checks, distinguishing their liability from that of a managing director or a signatory. So after going through this analysis, after going through these precedents, the Honorable Supreme Court, in its operative portion, said that giving the lack of specific allegations and in view of the aforesaid observations, the appellant cannot be held vicariously liable under the Section 141 of the NI Act, right? And the proceedings against the appellants were ordered to be quashed. So if we try to learn the findings from this judgment very categorically, that if you being a non-executive director or non-signatory director, and if you do not have any role in issuance of the checks, if you do not have any role in the managing the day-to-day affairs or the financial affairs of the company, then you have a pretty much chances of getting success in the check bounce matter. And primarily requirement is the you must be very clear about your role. If you are able to adduce evidence, if you are able to bring such facts before the court, there are fair chances that you will not be held liable under section 141 of the NI Act, even if you are a director of the company, right? Then non-signatory status is the key. Obviously this helps a lot because it is presumed if your signatures are found on the dishonored check, and if you are a director, if you have signed on behalf of the company as a capacity of a director, then you definitely have to establish other defenses, merely that you do not have any role, you are not involved into financial transactions. Unless you don't have a cogent evidence, you will have a tough time while defending such trial. And very interestingly, this point is very very important. See, what we have generally seen, uh, that the complainants tend to phrase things in a mechanical manner, that so and so is a director, so and so is involved into day to day affairs, and that's why they are liable under section 141 of the NI Act. The judgments, the law says that you have to explicitly explain what are the various facts and the circumstances based on which you have made a particular director who is a non-signatory to the checks, who has no role, or who may be a silent director, who may be a non executive director, still you have made them as a co-accused in the complaint. You must come out with specific allegations. Mere vague statements, mere one liner or two liner saying that yes, they were involved into day to day affairs, it's not going to help your complaint. And finally, from the complainant perspective, again, that drafting is very very important. Your complaint must contain clear, specific and unambiguous averments showing how each accused director was in charge and responsible when the offense was committed. आई होप इस जजमेंट से अपना ये अंडरस्टैंडिंग क्लियर हो गया होगा कि अगर हम कंप्लेंट में किसी भी डायरेक्टर को एज ए को अक्यूज बना रहे हैं इन ए चेक बाउंस मैटर में, तो हमारी कंप्लेंट के अंदर स्पेसिफिक अवर्मेंट्स अगेंस्ट द डायरेक्टर इन्वॉल्वमेंट इन द ऑफेंस हैज़ टू बी डिस्क्लोज्ड। अगर वो नहीं किया तो देन कंप्लेनेंट को टफ टाइम रहेगा उसको अक्यूज को की लाइबिलिटी को एस्टेब्लिश करने में अंडर सेक्शन 141 ऑफ द एनआई एक्ट। सिमिलरली जो नॉन एग्जीक्यूटिव डायरेक्टर्स हैं, इस जजमेंट से उनको ये हेल्प ज़रूर मिलेगी दैट देयर इज़ ए क्लियर कट ऑनरेबल सुप्रीम कोर्ट रूलिंग दैट अगर नॉन एग्जीक्यूटिव डायरेक्टर्स जो हैं डेली फाइनेंशियल डे टू डे डेली डिसीजंस में इन्वॉल्व नहीं हैं, and they are only into the corporate governance related tasks, then there are fair chances कि उनके against जो check bounce के matters हैं, they may be quashed once they approach the appropriate court. And if you have any specific questions or specific queries, you can send us an email or you can put your queries in the comment box also. हम कोशिश करेंगे कि जल्दी से जल्दी आपके questions को, आपकी queries को address कर सकें. And if you wish to continue to receive updates from our this YouTube channel regarding the recent judgments about the check bounce matters, feel free to subscribe to this channel. And thank you very much for going through this video. Jai Hind.